Done.
Thank you. Okay, so let's officially convene this and get started on, let's see, it's August 9th. Let's get started on where we left off, which I think was the beginning of part 4. Is that correct? Section 1041?
Yeah, conversions.
Okay, so I will turn it over to you guys and mute myself.
Okay, so Michael and I are going to do it. We split it up. I'm going to do the first 3 sections, 1041, 42, and 43, and then Michael will do the next 3. Are we good with that, Michael?
Yes.
Okay.
Good morning.
All right. So again, I don't think this is going to take long, although there's one thing I'd like to get us focused on that I don't think we did in the past. But again, this is very similar to, mergers and domestication and it's all very similar language. So I think we can kind of go through it quickly. So let's just start with 1041. The comparable is ORS 63470. I'm going to read the first one, 1041A, and then come back and address just a couple of issues that I'd like to focus on. So 1041A, by complying with this part, a domestic limited liability company may become 1, a domestic entity that is a different type of entity, or 2, a foreign entity that is a different type of entity if the conversion is authorized by the law of the foreign entity's jurisdiction of formation. So the first thing, and this is, first thing I want to focus on is to look at the definition, because I don't think we've done this, and it kind of gave me a little bit of heartburn, is to look at the definition of entity, which is on page 177 of ROLCA. And then we have the comparable definition in ORS is 63467-1A. Actually, excuse me, just 1, which is called business entity. So looking at ROLCA on page 177, entity means business corporation. I'm just going to make comments as I go. One of the things that I note is there's no reference to the PC. And if you look at 63467-1A, capital A, you've got the professional corporation. So ROLCA seems to be missing that, which is odd. Second one on ROLCA is a nonprofit corporation. If you look at 63467, no reference to nonprofit. So 2 big distinctions there. Keep going down the entity definition of ROLCA, you get down to clause 4, including a limited liability, limited partnership. We don't have those. We have LLPs, which is in 3, but not LLLPs. Then you got 4, limited liability company. Then you got 5 and 6. Again, I'm looking at ROLCA, a general cooperative, a limited cooperative association. I've never dealt with cooperatives before, but I don't think we have a distinction between limited and general. Does anybody know if we do under Oregon statute? Okay, that again may be a distinction. Then you get down to clauses 8, 9, and 10, and they're just not in the ORS. You can take a look what they are: unincorporated, nonprofit association, statutory trust. So there's a difference between the definition of entity, which applies through all of these things, mergers, domestication, they're all using that entity definition. And then when you focus on conversion, you look at the definition of business entity, it's again, different. So why is that relevant? Because when I look at 1041A, it says, by complying with this part, a domestic limited liability company may become a domestic entity that is a different type of entity. And when you look at that definition of entity, it may become something that our state doesn't authorize. For example, PCs or nonprofits. Actually, our state, authorizes PCs, but ROLCA doesn't. And then our state doesn't authorize a conversion to nonprofits. ROLCA does. So there are these distinctions. Not to mention these other types of entities, 8, 9, and 10 in the entity definition. So I was thinking, go ahead.
I may be moving a little slow this morning with my brain. So are we more worried about what 1041 does, or are we more worried about the definitions? Because if 1041 says you can convert to a different type of entity, and the concern is we don't define entities the same way in Oregon, Is that a definitional problem or
Well,
a problem with 1041?
It is, and things may change, over time. So again, for example, ROLCA authorizes a conversion to nonprofits, to a nonprofit entity. The ORS doesn't. So what I was going to suggest is in the language, one way to fix this in the statutory language, look at, for example, read A1. By complying with this part, a domestic limited liability company may become a domestic entity that is a different type of entity. And I was going to suggest adding the words, a different type of entity authorized by this state. So what we do by putting in the language, and the same thing when I get to 2, a little different language, but we can fix the problem just simply by saying authorized by this state. And so whatever, and then if changes occur over time in state law, which it will, because we're going to change other acts, then that language will simply pick it up as it goes. But I was a little bit concerned with the way it is now, because technically it's authorizing the way it reads now, us, for example, to convert to something that is that it doesn't exist under Oregon law right now. Take A2, a foreign entity that is a different type of entity. So what I was thinking there is a different type of entity authorized by the foreign entity's jurisdiction. And by adding that kind of language, you fix the disconnect in the definitions, and then you also allow the definitions to catch up later on if we change things in different acts. And why I think it's important, I wanted to bring it up here, is because I think we would make, if we agree, make these same changes to the other parts, the other subchapters, to merger and domestication to fix the same problem.
Jeff, that you just raised the point that I wanted to raise as well, is that, the definitional section covers all these different kind of entity changes in this chapter, and you look at 1021 under merger. I mean, it's the same issue. It goes back to those same definitions, and part of the policy here is what is legislative council going to want to do? And we've talked about this before. Are they going to want to change these merger and conversion statutes in such a way that they don't sync up with the other entity statutes that we're not touching at this point? So it's a real dilemma. As we communicate to legislative council, I think we need to communicate this dilemma clearly. But I agree. I think we have this definitional problem across this whole chapter.
I don't know how big a problem it really is from my perspective. I think if you filed articles of conversion saying you're changing to an Oregon LLLP, I think the Secretary of State's going to send you back your documents and say thanks, but no thanks. But your wording is clearer. I would be comfortable with your wording. I'd also be comfortable with a comment.
That's another way to handle it, as a comment, just to recognize that the definition of entity does not line up with current Oregon law, and it won't when we fix this act, not completely.
I guess I would lean towards a comment because, again, we don't know where legislative council is going to want to go with this. And so I think a comment tees up the issue and sort of the definitional disconnect that we're seeing here.
Okay, so I have a note just to, look at all of these sections with respect to that definition, but we'll put the comment in the definition section probably.
Okay, all right, so I'll keep moving on. So then we're in 1041B. I didn't have any other comments. Anybody have any other comments to 1041A? Okay, so let's move on to 1041B. And this is 63471A is the comparable. By complying with the provisions of this part applicable to foreign entities, a foreign entity that is not a foreign limited liability company may become a domestic limited liability company if the conversion is authorized by the law of the foreign entity's jurisdiction of formation. So what I would point out here is again, we had discussion whether we wanted domestication or not. Notice that this is limited to that is not a foreign limited liability company. In other words, B does not apply to limited liability companies. And And so that's why you have domestication. So in essence, you have to have domestication if you're going to accept B. Other than that, I thought the language was fine. Any comments?
I missed the reference. What ORS section did you say it relates to?
It's 471A. Again, it's the definition. What am I doing here? Where is it? Yeah, 1A. And the difference there was 1A says, ORS 1A, a business entity may be converted to a limited liability company organized under this chapter. And so it allows LLCs, foreign LLCs, to be converted to Oregon LLCs because we had no domestication process.
Yeah.
That's the only distinction really for the most part. Otherwise, I was fine with it. Okay, then if no other comments, moving on to C. If a protected agreement contains a provision that applies to a merger of a domestic limited liability company but does not refer to a conversion, the provision applies to a conversion of the company as if the conversion were a merger until the provision is amended after the effective date of this act. We've seen this in all 4 parts. I think we're all fine with it, so I had no comment to it. So unless there's any other comments, we're on to 1042. Plan of conversion.
Mhm.
Okay, so what we're looking at here is 63-470, subsection 3 and subsection 4. We have an A and a B. 1042A is subsection 3 of ORS 63-470, and 1042B is 63-470, subsection 4. Okay. So first sentence of 1042A, a domestic limited liability company may convert to a different type of entity under this part by approving a plan of conversion. A couple of things I want to unpack there. First off, this is just I don't know if it's philosophical or what, but notice that it only applies to a domestic LLC. So if you have a foreign LLC converting to an Oregon LLC, then our rules of plan of conversion, like subsections 1 through 7, don't apply. You look solely, as I understand it, reading this, you look solely to the foreign jurisdiction for what will be in the plan. And so my first question is, we've got 49 other jurisdictions, more actually, if you take, protectorates or other, whatever is part of the US. And so we would be relying in terms of what would be in a plan of conversion when it comes to a foreign LLC, we'd be relying on what's in the other states. So the question is, should our plan of conversion rules apply to a foreign LLC converting? And notice when you look at ORS, it does. So if you're a foreign LLC converting to, or a foreign entity, whatever it is, converting to an Oregon LLC, you're going to have to comply, that foreign entity is going to have to comply with our plan of conversion rules. In this particular case, 1042, it's only a domestic limited liability company that has to comply with our conversion rules. If it's foreign, you simply look to what's in the foreign statute for what's going to be in that plan of conversion. And the question is, are we okay with that?
That makes a lot more sense to me, to be honest.
Why would we not be okay with that?
Right.
Just because it might be different stuff. Who knows what's in the other statutes? At least if they're complying with us, then you get 1 through 7. You're sort of guaranteed that. That's all.
Well, the entity will still need to comply with 1045, right? Filing the statement of conversion. And I think that's what our state really cares about, because in a lot of ways, this is the equivalent of forming a new Oregon LLC from our state's perspective. And if that's the case, I think 1045 covers what we care about as a state.
Yeah.
Unless there's something I'm missing.
I guess I would add, similar to Valerie, I think this 1042 is an improvement. And keeping in mind also that you're dealing in a conversion with a single entity. And so if that entity is at the beginning of the process controlled, say, by maybe a Washington corporate statute, and you're converting to an Oregon entity, it seems like you do need to start with the statute by which the entity was created and follow the pathway of that statute to determine if it can be converted to, in my example, the Oregon LLC. And so I think, like a lot of places, I think Roca is an improvement in terms of clarity.
I mean, I agree with that. I don't have necessarily opinion one way or the other. I'm more, just so everybody understands, kind of issue spotting and
Yeah, no, I don't
interested
think,
in the
I don't think
input.
it's a criticism. It's not a criticism.
Yeah,
but-
yeah, no,
No,
I get that. I'm not wedded to one position or the other. I'm just more, I want to issue spot things that I think we should at least discuss and flesh out.
Great.
No, good points.
All right, but so are we in agreement that no change here? Okay. The second thing I want to point out with that first sentence is, notice it ends with this part by approving a plan of conversion. If you look at, where is it? It's 63-471C. 1C says a business entity may perform a conversion described in paragraph A or B of this subsection by approving a plan of conversion and filing articles of conversion. The question I had is, should we be adding the words "and filing articles of conversion"? This says a domestic limited liability company may convert to a different type of entity by approving a plan of conversion. Well, they also have to file articles or a statement. Articles may not be the right thing. They have to file something with the Secretary of State, and ORS does list you have to file articles of conversion in the comparable language. And here it just stops at plan of conversion.
Jeff, I think if you go to 1045, which I believe Michael's covering, it talks
Yeah.
about what you file with the Secretary of State.
No, I get that. It's a little bit of a disconnect because later on you have articles in plan 63-476. So in ORS, it does it in both places, if you will. Here, oddly enough, it covers it in 1045, but it just didn't do it in 1042. And I'm a literalist.
Well, but if you're a literalist, you look at the heading and you say it only refers to a plan of conversion.
I know. And 63-470 just says conversion. I understand. It's just, again, I'm looking at the comparable language between ORS and here and just drawing the distinction. I think it's fine, but
Okay.
I thought I'd put it on the table. Okay.
Yeah, I would say that without going through 1045 and filing the statement of conversion, there will be no conversion. So I guess when you put it in the blender, I think it's very similar.
Okay.
Roca is just more sequential, I guess.
Okay. All right.
Jeff?
So then, go ahead.
Sorry, I want to go back to 1041C. If the discussion here is done.
Yeah, I was going to move on to the next sentence. Go ahead.
Okay, so sorry, the pause wasn't long enough for me to interject when you paused on 1041C. This is a small point, but I just want to raise it. I don't have a dog in the fight. I don't have a view. I just want to raise it so everyone's aware. This language makes sense. Where we saw this language before was in the interest exchange context. And in my view, it made sense in that context because interest exchanges would be new to the law of Oregon. Here, a conversion is not new to the law of Oregon, and therefore, arguably, contract parties do not need the protection the statutory provision provides. This is giving them something that they don't need because they are already aware when they enter contracts with Oregon LLCs that they can convert. This would give them that, even though this kind of language, this kind of transformation is not new to our law. If everyone's fine with that, then we can move on. But I just wanted to raise that.
Well, and conversions have been around since what, 1993?
So when a contract says a merger requires the consent of the counterparty, now that counterparty will also have the right to consent to any conversion, whereas under existing law, unless there's comparable language under existing law, which I'm not aware of, they wouldn't have that right.
So exchange and domestication, you would have it because those would be new to our state, but you're suggesting conversion since it's been around for what, 20 years?
If contract parties wanted the right to consent to that, they should have contracted for it.
I think that's a really good point, Mohsen. And the commentary in the interest exchange section emphasizes, because the concept of an interest exchange is relatively new, ... This is why this protection is needed. I think it's a really good point you raise. I would, however, argue that for domestication, that would be treated the same as conversion because domestication is a subset of conversion as it exists today.
And so we should keep this language on.
No, meaning this language would not be necessary for either conversion or domestication.
Right. I would make the same points.
But if we're saying it's implicit, why take out the express? Why not? I hate relying on implicit, something implicit in language if we agree to it and it's expressed. So you're saying take it out, it's implicit. Why not just leave it in?
No, I'm not saying it's implicit. I'm saying it should be struck. Arguably, it should be struck because this is giving contract parties a right they don't deserve, which is we're not springing something new on them by allowing for conversions. Conversions have been around, and if parties who contract with LLCs wanted the right to consent to that LLC's conversion, they should have contracted for it rather than the statute giving them that right. Does that make sense, Jeff?
Yeah, yeah. I could go either way on this one.
I don't feel strongly about it either. James, Wilson, do you feel strongly about it?
I think for logical coherence, it shouldn't be in here, but I think it's a small point.
I think Wilson's right.
The point I would recognize that if a future court was looking at this and we deleted it, then I think that court would be bound to interpret that we deleted it for a reason, and that it could be a problem in someone making the argument that, well, it's just implied. And so, I understand that, parties' freedom of contract, you need to be specific in your contract. But, I guess when we think of the concept of merger versus conversion, I read it as saying, well, it's a similar animal, and we're going to have that cover both kinds of changes to the entity. So
Michael,
I don't know if I feel strongly about it. I just think that court interpretation issue is something that could come up.
Well, Michael, what I hear you say is that we should have the opposite language, that unless a contract specifically says the party has a right to consent to a conversion, no such consent right would exist. Because what this language says is if a party has a right to consent to a merger, they also now have a right to consent to a conversion.
Mm-hmm.
I like the idea of striking it and adding a comment along the lines of what Mohsen described, that we're not trying to create rights that don't exist today. Conversion has been around for a while. We're also not commenting on interpretation of any existing contract as it exists today. We're just not trying to add rights.
That would be my proposal, but it's a small point again.
Take a vote on it, Valerie, or how do you? We can't hear you.
Oh, you're muted.
Sorry, my vet called while I was talking. Did Kyle and Aurelia have a chance to comment on this? Because I do kind of want to hear what they think this would look like on the back end, which, the litigation side of things.
I think I'm in favor, if we're going to delete the language, of including a comment as to, why, because that does help with the interpretation issue.
Okay.
And would the comment suggest, as Mohsen did, that some of them are sort of covered by domestication and exchange? Some, not all.
Right. Yeah, I think that's right.
Kyle?
Yeah, I think that sounds like a reasonable approach to me. I don't perceive any other, significant issues that would come up on the back end.
Okay. Mohsen, James, would you mind putting together a comment just to sort of encapsulate that?
And if you could just send it to me, I'll add it to the notes. No hurry. Thank you.
Thank you, Mohsen.
Okay.
Is anybody feel strongly opposed to this course of action? Okay.
Okay, keep going.
Right.
Okay, so second sentence of 1042A we're going to cover 1 through 7, which is what's in the plan. A lot of this stuff is in ORS, some of it is not, but I'll just go through it quickly. The plan must be in a record and contain 1, the name of the converting limited liability company. That's covered by subsection 3B of 63-470. Number 2, the name, jurisdiction of formation and type of entity of the converted entity. That's in subsection 3A of 63-470. Number 3, which is 63-473D. Number 3 in ROLCA is the manner of converting the interest in the converting limited liability company into interest, securities, obligations, money, other property, rights to acquire interest or securities, or any combination of the foregoing. The only comment I'll say is the ORS version said the manner and basis of. I know we addressed that and basis language in the other parts, and I believe we decided not to include it.
Right.
So I think we'll do the same here. Then you get into subsection 4 and 5. Neither of these are in the ORS, but I don't think we have problems with them. 4 is the proposed public organic record of the converted entity, if it will be a filing entity. And then 5 is the full text of the private organic rules of the converted entity, which are proposed to be in a record. So to me, that's the entire operating agreement. I don't think we have any objections to that, but know that ORS never required the full operating agreement, and ROLCA is essentially requiring a full operating agreement. And 4 is really the articles. So an add-on with ROLCA, but I don't think we had any objections. So I'll just keep going. Number 6, which is subsection 3C of 63-470. Number 6 is the other terms and conditions of the conversion. Again, subsection 3C of ORS uses a summary of the material terms, but I think we decided we discussed that and we weren't going to add a material. So I think consistent with the other parts, we're leaving 6 alone, unless I got that wrong. And then number 7, go ahead.
No, I think that's right.
Right, okay. Then number 7, any other provision required by the law of this state or the operating agreement of the converting limited liability company. This is subsection 3E of 63-470. It's a little bit different, but I don't think we had any objections to the language. So again, we'll stick with 7. So unless there's any comments, I'll move on to B.
Mhm.
Okay, B is 63-470 subsection 4. What B says is, in addition to the requirements of subsection A, a plan of conversion may contain any other provision not prohibited by law. The only difference with subsection 4 of 63-470 is says other provisions relating to the conversion. Again, I don't think we had any objections to this language as we did in the other parts. So no change, even though it's a little different.
Yeah, that
Okay.
looks good to me.
So that's 1042. Unless there's other comments, I'll move on to 1043. Okay. 1043, approval of conversion. Okay. Subsection A. Oh, and we're talking 63-473. So this is 63-473 is the comparable in the ORS. A plan of conversion is not effective unless it is has been approved, 1, by a domestic converting limited liability company, by all of the members of the limited liability company entitled to vote on or consent to any manner, and 2. Before I go on to 2, because that's lengthy, let's just revisit 1 for a section. My recollection is this is the majority versus unanimous issue. My recollection is we want to be consistent with all parts. We stayed with unanimous, correct?
Yes.
Okay, so no change here. Okay, and then subsection 2, there is no comparable in the ORS. Again, I think we accepted this language in the other parts. It says, and this is an and, so it's conjunctive, 1 and 2. In a record by each member of a domestic converting limited liability company, which will have interest holder liability for debts, obligations, and other liabilities that are incurred after the conversion becomes effective, unless A and B. A is the operating agreement of the company provides in a record for the approval of a conversion or a merger in which some or all the members become subject to interest holder liability by the affirmative vote or consent of fewer than all the members, and B, the member voted for or consented in a record to that provision of the operating agreement or becomes a member after the adoption of that provision. Again, I don't think we had any changes to that language in the other parts. If that's the case, then no changes here. Okay. Subsection B. We're looking at 63,473 subsection B for the comparable. B 1043B reads a conversion involving a domestic converting entity that is not a limited liability company is not effective unless it is approved by the domestic converting entity in accordance with its organic law. Again, I don't think we had any problem with B, so it's acceptable. And then finally, C, a conversion of a foreign converting entity is not effective unless it is approved by the foreign entity in accordance with the law of the foreign entity's jurisdiction of formation. Again, the comparable is 473 subsection 1B. I don't see any problem here. So I think we're good with this language as well as we were in the other parts.
Yeah.
Okay, so that's a quick run through the first three. Michael, why don't you
Good
take us
job,
through the
Jeff.
next three? Well, I'm trying to be fast and efficient.
Moving on, we'll try to stay equally efficient in the next three sections. Okay, so when you look at 1044, we're dealing with amendment and abandonment of the plan of conversion in different scenarios that come up there. This is similar to language that we've seen before. Now, just a point of clarification, and Motion, you did the interest exchange. I had a note on 1034B that we were going to delete that. Is my note correct there? Because if we're going to delete that, that's the equivalent of 1044A. And I'm not sure why we were, and my note could be incorrect.
I'll confess that my binder with my notes in it are in my office, and so I don't have that. So let me work on memory and see if I can get an answer to you.
My notes are that we were going to delete D as in dog, which is how you abandon.
Okay.
And I actually, since I'm prepped domestication, which comes up next, as I was thinking about that, I wondered whether we really do want to omit abandonment. You know, part of why I was okay with it when we first talked about it is that our Secretary of State does a really great job of filing everything same day, or at least historically has. And I worry what happens in the future if that doesn't continue. If we end up having 2 or 3 or 20-day delays like some states have, we may well want to file stuff early and then try to abandon it if we need to. So anyway, I just thought I'd flag that.
Yeah. As I look at this, it seems like having some of the points of flexibility on amendment or abandonment that's covered in 1044 ROLCA here makes a lot of sense. So let's maybe dive in and see where we end up in terms of whether we retain this language. So ORS, it does have a section on abandonment, but does not explicitly have a provision dealing with amendment. Now, just again, looking at freedom of contract, if we had a plan of conversion, it's probably interpreted largely out of contract principles. I think if it had a provision dealing with amendment of the plan, it would be interpreted according to general contract principles. So I think the concept probably exists implicitly in Oregon law. This I think makes it explicit. So you look at sub A, a plan of conversion of a domestic converting limited liability company. So that's an LLC that's converting to something else, may be amended. So sub 1, in the same manner as the plan was approved, if the plan does not provide for the manner in which it may be amended, again, gap filler there, or disjunctive there, 2, by the managers or members in a manner provided in the plan, but a member that was entitled to vote or consent to the approval of the conversion is implicitly there also entitled to vote on or consent to any amendment of the plan that will change. And you have a couple of points here. So sub A there really is the economics of the transaction, the amount of kind of interest, securities, obligations, money other property, rights to acquire interest or securities, or any combination of the foregoing to be received by the members of the converting company under the plan. And all these are disjunctive, by the way. So sub B, the public organic record, if any, or the private organic rules of the converted entity, which will be in effect after the conversion, except for changes that do not require the approval of the interest holders of the converted entity under its organic law or organic rules, or, and kind of a catch-all here, any other terms or conditions of the plan if the change would adversely affect the member in any material respects. So again, similar language to some of the other parts. Again, with respect to amendment, we don't have any explicit direct counterparts in ORS. Let me pause there, see if there's any comments.
This was
Okay.
the same language that we saw in mergers.
Yeah.
Yeah.
Hearing none. So another scenario here, after a plan has been approved by a domestic converting LLC and before the statement of conversion becomes effective, the plan may be abandoned as provided in the plan. So there is, while there's no counterpart in ORS to amendment, it does have a provision dealing with this scenario, the pre-filing abandonment. So 63473(2) indicates that after the conversion is approved at any time before the articles of conversion are filed, the plan conversion may be amended subject to any contractual rights, sub A and B below that, by the LLC without further action by the members in accordance with the procedure set forth in the plan, or if none is set forth, the manner determined by the managers. Interesting that it focuses on managers, that's ORS. Sub B, by a converting business entity that is not an LLC in accordance with the procedure set forth in the plan, or if none is set forth in the manner permitted by the statutes governing that business entity. So that's the language here in ROCA, a little bit different. I think in most cases, you might end up pretty much in the same place. So sub B continues, unless prohibited by the plan, a domestic converting LLC may abandon the plan in the same manner as the plan was approved. Again, similar language here. Comments, questions on B? Okay. Sub C, if a plan of conversion is abandoned, and again, this is another scenario, after the statement of conversion has been essentially filed, delivered to the Secretary of State for filing. So I guess it's the delivery that it's focusing on here, not necessarily the filing. And before the statement becomes effective. Now, noting the word effective, both in the statute and in the plan, you can have delayed effective dates in the plan. So that could come into play in this particular scenario where you have the filing delivered, but maybe you have a delayed effective date. So for filing and before the statement becomes effective, a statement of abandonment, which would be a new filing from something we don't have currently under ORS. A statement of abandonment signed by the converted entity must be delivered to the Secretary of State for filing before the statement of conversion becomes effective. So the statement of abandonment takes effect on filing and the conversion is abandoned and does not become effective. So the statement of abandonment must contain 1, 2, 3, name, date on which the statement of conversion was filed, and a statement of the conversion has been abandoned in accordance with this section. One might be able, under current Oregon law, you might be able to do something similar with articles of correction. That'd probably be a Secretary of State interpretation, whether we could do that to, in effect, undo a filing before it becomes effective. So that's sub C.
Michael, my notes actually indicate, you had mentioned earlier about, I thought you said deleting B. My notes indicate what we did in the merger sections, we deleted C. And that would kind of make sense because this is after you filed the statement. And my recollection also is another form, and a statement of abandonment and the cost of that. So
Yeah.
My notes indicated we deleted this in merger subsection C.
Yes, that's my recollection. Like I said, I don't have my notes.
Any,
That's-
okay.
But then I'm interested in what James had to say about why we might want to retain this language in all four of the transformations that we're talking about. I was not aware that there are secretaries of states in this country that take more than 24 hours to file entity formation documents.
Washington.
California recently was something like 3 weeks behind.
Ooh.
And there isn't a thing you can do. There isn't a fee you can pay and expedite anything.
Oh,
There's no way around it.
Yeah, and our filings, and I think Jamie is on the call. Our filings are effective not when they land with the Secretary of State, but when they're processed. So if we have scenarios, and we have a great Secretary of State's office, and they do file things quickly, but if we have a scenario where there's a delay, that's, I think, one scenario where this could come up. And also, again, if the terms of the filing have a delayed effective date, so you file something on December 1st and it has a delayed effective date saying it's going to be effective on December 31, but in the intervening time, there's a problem that comes up and all parties say, no, we need to not do that. We need to abandonment. Maybe Congress has changed the tax laws or something in the intervening time and we want to abandon that step. It seems like a scenario, again, a tool in the toolbox that I think probably has limited utility, but I don't know why we would want to take that tool away per se. I don't think it's creates a problem, but just my thought.
I would just agree. Let's be consistent in all four parts. Either leave this in or take it out.
Again, I don't know why we really need to take it out. Does it create a?
I think the reason that we had thought to take it out was that it was it was not deemed to be necessary.
Yeah, my recollection was the very limited utility of this option, coupled with the fact that it would require the Secretary of State to have a new filing they would need to accept, and there might be budgetary consequences that spin out of that that led us to conclude this was not worth the costs were not worth the benefits. But this new information could sway me in the other direction, I think.
Jamie, do you have any thoughts about this?
One of the other things that we see is they'll do the unfiling. So they'll it's under 56080, they can withdraw filing, and that's what I've seen most. But as we're talking about this, I start thinking about the end of the year and how we have a lot of times where customers will want to do a conversion or a merger. I mean, we see them mostly at the end of the year. We see them, I can't even say that anymore now. We're seeing them all the time, but we see them with delayed effective dates mostly at the end of the year because they're looking at, December 31st or January 1st. So I could see where this might be something that people would like, and just to have a different option. But right now, I think what we've been seeing is them just withdrawing the filing. With 56080.
Can you withdraw a filing after it's effective though?
You can actually withdraw filing up to a year.
Okay. Wow. Okay. Never done that, but okay. Even after it's effective. So you take something that's effective, you withdraw it, and you make it ineffective.
Right.
So if you can do that, why do you need to have an abandonment provision if you can just go ahead and withdraw it anyway under our law?
Jamie, does the withdrawal section have any discretion? I've never done it before, but are you guys required to withdraw?
If they fill out a form and they want to withdraw it within a year, then we would withdraw it. So let me see if there is, there are certain things that they have to follow. Let me just go to it
Well,
really fast.
A
Yeah, what
year
was
should
the
be
site
good
again,
enough.
Jamie?
A year should be good enough unless you're setting the effective date out more than a year on your filing. So that's a nice window.
It is within 1 year after the filing. A filing may be withdrawn, or let me actually read it the right way here. The secretary within 1 year after a filing may withdraw from filing any document. Let me make sure I'm in the right spot. Sorry.
Heard the word may.
And it's also
Yeah.
limited to, I screwed up. I accidentally submitted it too early.
Mhm,
That's my mistake. I'm
Yeah.
more worried about the scenario where plans have changed. It was fully intended at the time, but now we've changed our minds.
Yeah, my scenario where the ground changes underneath the feet, Congress changed the tax law, and all of a sudden what we're doing would be a terrible result. I guess, Jamie, looking at these kind of filings, these statement of abandonments, I presume Secretary of State would charge the same standard filing fee, $100 on these kinds of filings.
Yes.
I mean, would it present a burden on your office to add a couple of these extra filings that are optional, obviously, as part of what practitioners could do?
We're going to be making changes anyway. We're going to have to with all of this. So I think that it just fits it all into one package at that point. Once we really get to the end and figure out exactly what we'll have to make changes to. Adding a form, we're going to be have to change the forms anyway. So that's all going to have to happen. Adding transactions, sometimes, there can be some work behind that, sometimes not. So it'll just depend on what our developers say at that point. But we are going to have changes. So that's going to have to happen for sure. But I just also wanted to mention, it did say under 56080, it's prematurely, inadvertently, or by mistake is what they say if they need to unfile something.
So it has limited scope.
Yes.
There's
yes,
a standard. There's a standard that has to be met.
definitely.
So what I'm hearing is that, these 4 sections that we had sort of deleted because we didn't think they added anything, as a belt and suspenders against future issues might be useful to incorporate into this draft.
I'm thinking that way.
To put them back in, Val, I was confused.
Yeah, I think to put it back
in.
in. I think we have to be consistent as between these 4. And I think James's point is very well taken. So I've flagged all 4 sections to, fix my notes on.
I'd be in favor of putting them back.
Okay. Anybody feel strongly that we should continue to leave them out? Okay.
Righty. Anything more on C? Okay. 1045, the statement of conversion effective date issues. So we see the coverage of the articles and plan of conversion in ORS at 63.476 sub 1. And just since I'm there, that says after the owners approve a conversion, the converting business shall file articles of conversion that state the name and type of business entity that existed before the conversion and the name and type of business entity that will exist after the conversion. And then it jumps into sub B. It allows you to file the plan of conversion, or in lieu of the plan of conversion, a written declaration that identifies an address of the office of the converted entity where the plan of conversion is on file, and state that the converted entity will provide any owner with a copy of the plan of conversion upon request and at no cost. Sub B, I read that because I think consistent with our other parts, we want to add that as a part of 1045 as we did with the other sections. Because ROLCA does not have that, does seem like a clear policy of the legislature to have the plan accessible somewhere statutorily. I think that makes good sense. So that's really where the coverage is in ORS counterpart here. So looking at ROLCA 1045A, a statement of conversion must be signed by the converted entity and delivered to the Secretary of State for filing. Definitely similar there. A statement of conversion equivalent to our articles of conversion must contain the name, jurisdiction, type of the converting entity and the converted entity 1 and 2 there. And if the converting entity is a domestic LLC, a statement that the plan of conversion was approved in accordance with this part. Or if the converting entity is a foreign entity, a statement that the conversion was approved by the foreign entity in accordance with the laws of that jurisdiction of formation. Sub 4, if the converted entity is a domestic filing entity, it's public organic records as an attachment to that statement of conversion. And then sub 5, if the converted entity is a domestic LLP, the statement of qualification in Oregon, that's an application for registration, is the counterpart LLP filing the statement of qualification as an attachment. So it's really at that point that I would probably add a sub 6 that brings in the language from 63476B, whereas you need to file the plan of conversion or make it available, one or the other. I'd probably plug that in as a sub 6 under B there. Let me pause.
Michael, I haven't drafted that language. We agreed that language needs to be added. The only point I will make is that we need to be using the same language in every part of these 4 transformations.
Right. Right.
And so the question is, who's going to do the drafting?
I think I already roped Mosen into drafting one, so he's off the hook for this one. But does anybody else feel up to the task? Michael?
I'd be, if Mosen is looking at that, I would be happy to look at it, and if it needs any sort of melding to fit into part 4 here, be happy to work with Mosen on that. So.
Well, I think Valerie wasn't volunteering me, but I'm happy to do it.
I wasn't volunteering.
Yeah, no, but I'm also happy to do it.
Okay.
I have this other assignment. So what I'll do is I'll draft language appropriate for the merger section, and it will I'm assuming it'll be conforming language. It will go in the other 4 parts, and so I'll circulate with the relevant group of presenters. And if we're all content, then we can share it with Sandy and Valerie.
Okay, yeah, I didn't want to because you'd already volunteered to do the comment to 1041. So
no, that's fine. It was already kind of on my to-do list. I just haven't done it yet.
Okay.
Sub C, no direct counterpart there, although it's similar to what we've talked about in terms of the plan of conversion. In addition to the requirements to be a statement of conversion may contain any other provision not prohibited by law. I think that's consistent with our prior language that we've retained. Sub D, if the converted entity is a domestic entity, its public organic record, if any, must satisfy the requirements of the law of this state, except for the public organic record does not need to be signed. There's no counterpart in ORS. Seems odd that to me that it doesn't need to be signed. I don't know why that particularly is. I don't know if that.
There's a note. It's similar in the other ones too. And somewhere
Yeah.
there's a note that explains it's because the thing it's attached to, the statement of conversion, is signed.
Okay,
So you're effectively
really
signing it at the top level.
it's incorporated there in effect the master filing. So okay, that makes sense. Sub E, a plan of conversion that is signed by a domestic converting LLC and meets all of the requirements of subsection B may be delivered to the Secretary of State for filing instead of a statement of conversion. So this in effect allows you just to file the plan of conversion directly in its own right. Seems like would be a good option in some situations, particularly maybe simpler types of conversions. If a plan of conversion is filed as providing the subsection references to this article to the statement of conversion, refer to the plan of conversion filed under this section. Seems like, again, in maybe simpler conversions, this would be a good option to have in the toolbox. I'll pause there, see if there's any issues on E. Hearing none, sub F. If the converted entity is a domestic LLC, the conversion becomes effective when the statement of conversion is effective. And here I'd refer us back to the section 207 of ROLCA that deals with time and effect, the effective date of filings. So you really have to read section 207 and what we've done there already into this provision. So continuing on, in all other cases, the conversion becomes effective on the later of the date. And I think consistent with what we've done before, aren't we striking the verbiage and time? I think we've done that before.
Yeah, I think that's correct.
Yeah, so F1, strike and time. So it would read the date provided by the organic law of the converted entity. And again, this is the later of that date and the when the statement is effective. Also, just the ORS counterpart 63.011 covers some of the effective date issues there, just for cross-reference back to ORS. Pausing there, comments, questions?
Nope.
Okay. Moving right along. 1046. So this is effective conversion. The counterpart section is 63.479, and there are a lot of parallels here. There's some additional issues that ROLCA hits that aren't covered by RS. So starting in sub A, when a conversion becomes effective, the converted entity is A, organized under and subject to the organic law of the converted entity, and sub B, the same entity without interruption as the converted entity. So you can see pretty close counterpart there in sub A of 63.479. The business entity continues its existence despite the conversion. So similar concept worded differently in ROLCA, maybe makes it a little clearer than ORS, frankly. So sub B, all property of the converting entity continues to be vested in the converted entity without transfer, reversion, or impairment. Now let's compare that to the counterpart in ORS sub B of 479, title to all real estate and other property owned by the converting business entity is vested in the converted business without reversion or impairment. You notice that the additional word that ROLCA adds there is without transfer. And I look at that and say, okay, look at issues such as due on sale clause that would trigger due on sale upon a transfer. And if you have a conversion, this makes it explicit that a conversion does not constitute a transfer of property.
Yeah.
So I think that's,
It also avoids real property transfer tax issues.
Yeah. Well, and you know, it avoids the necessity of transferring. I've done conversions of real estate entities before, and I've done the deed just so that title on the property shows the converted entity. And this sort of takes away the necessity of that.
yeah. And I think title officers would appreciate this section because it adds that reference to transfer, that it's not a transfer. So I think an improvement there.
Well, and it takes away the necessity of doing the transfer.
Right.
Yeah. I think under current law, I think sometimes it's left to interpretation, and when in doubt, you do the transfer.
And that's why I've done it, is title purposes.
Yeah, that title officers, you know, that's sort of their mindset, that if they don't have rock solid foundation to stand on, then yeah, they make you jump through the hoops, which I understand.
They won't insure it.
Yes. So sub 3, all debts, obligations, and other obligations of the converting entity continue as debts, obligations, and other liabilities of the converted entity. Similar to sub C of ORS 479, all obligations of the converting business entity, including without limitation contractual, tort, statutory, and administrative obligations, are obligations of the converted entity. Phraseology is different. I think in substance it would, I don't know if I see a lot of difference there, but we'll pause, see if there's other thoughts. Okay, sub 4, except as otherwise provided by law or the plan of conversion, all the rights, privileges, powers, and purposes of the converting entity remain in the converted entity. I think there's no direct counterpart in ORS. I would say it's sort of implied in 479A, which basically says the business entity continues its existence. But I think that's implied there. I think this makes those particular aspects explicit. I don't have a problem with it. So sub 5, the name of the converted entity may be substituted for the name of the converting entity in any pending or proceeding. You see similar concept in sub D of 479. Action or proceeding against the converting business entity or its owners may be continued if the conversion has not occurred, or the converted business entity may be substituted as a party to the action or proceeding. So I think substantively very close. Sub 6, the certificate of organization of the converted entity becomes effective. So I don't think there's any direct counterpart in ORS to that one, but don't see it as real problematic. Sub 7, the provisions of the operating agreement of the converted entity, which are to be in a record, if any, approved as a part of the plan of conversion, become effective. No counterpart there to ORS, not particularly problematic. And then sub 8, the interests in the converted entity are converted, and the interests of the converting entity are entitled only to the rights provided to them under the plan of conversion and to any appraisal rights under section 1006. So that reference to appraisal rights is not directly in ORS. The first part, you do see a counterpart in 479 sub E, the ownership interest of each owner that are to be converted into the ownership interests or obligations of the converted business entity or other business entity, or into cash or other property, are converted as provided in the plan of conversion. So
I
there's,
think that's fine though, right? Because you only have those rights to the extent that you specify them.
yeah, so not particularly controversial, I don't think. Consistent with where we are with some of the other parts, I think the sections that we're dealing with, the subparagraphs in 1046 here that deal with interest holder liability, and that's a defined term in this chapter. When we look at the concept that we see in 63479, we've touched on this before in the other parts. You remember this sub G of 479 says if prior to the conversion an owner of a business owner entity was a partner, and the partner, general partner of the limited partnership was personally liable for the business entity's liabilities, and after conversion is an owner normally protected from personal liability, then such owner shall continue to be personal liability for the business entity's liability incurred. So this is post-conversion, incurred during the 12 months following conversion if the other party or parties to the transaction reasonably believe that the owner would be personally liable and had not received notice of the conversion. So again, consistent with the other parts, I would probably plug that in at this juncture.
That's what we did in 26 and 36 as well.
Right. So I would probably plug it in as a new C, just so it's clear. It really, I think, makes logical sense because it talks about a partnership inbound to presumably an LLC here. And I think also not, we added in the other parts the reference to the assumed business name of the converted business entity continuing. That is sub 8 of 3479. I think I would just continue on and add a new sub D there that tracks with that language. So we're again consistent with the policy ORS and what we did in the other parts.
Mhm. Yep.
Okay.
Yep.
So I think those would be the plugins from ORS in 1046, and then continuing on. RILCA sub C of 1046, when a conversion becomes effective, a person that did not have interest holder liability with respect to the converted entity and becomes subject to the interest holder liability with respect to the domestic entity as a result of the conversion, has interest holder liability only to the extent provided by the organic laws of the entity, and only those debts and obligations or other obligations that are incurred after the conversion becomes effective. And as I recall, I think we retained that in the other sections. Yeah. Sub D, the longer section, I think we retained this in the other section, and I don't need to read it. You're essentially dealing with when a conversion becomes effective, the interest holder liability of that person ceases to, of a person that ceases to hold an interest in a domestic LLC with respect to which the person has interest holder liabilities subject to the following rules. And I think 1 through 4, again, cover various situations there. I think it's consistent with prior parts. Any thoughts, questions, comments on that sub D? It's in effect where you're outbound from an LLC, if I read it correctly. where they cease to hold an interest in a domestic LLC.
Mhm,
Okay.
mhm.
Moving on, sub E, when a conversion becomes effective, a foreign entity that is the converted entity, so sort of an inbound foreign entity that is the converted entity may be served with process in this state for collection and enforcement of any debts, obligations, or other liabilities as provided in section 119, which we've covered in the past.
Right.
So F, if the converting entity is a registered foreign entity, its registration to do business in this state is canceled when the conversion becomes effective. Just really almost a housekeeping item there that eliminates the duplicitous filing of the prior registration. And then sub G, a conversion that does not require the entity to wind up its affairs and does not constitute or cause the dissolution of the entity. So again, similar to what we've had before. That's 1046, that's part 4. Comments, questions?
Good job. Nice efficient coverage. I think you guys set a record.
The road was already paved, thanks to the other team members.
Okay, well, why don't we take a break and come back in 10 minutes? So come back a little bit after 10:30. Does that sound okay?
So part 5 is domestication. Just starting off with a little bit of terminology. Domestication is a transaction where the state of your organization or formation changes, but your entity type doesn't. I think everybody probably knows that by now. Domesticating LLC is the one that adopts the plan. It's the before picture. Domesticated LLC is the entity on the other side. It's the after entity. And I would note in the definition of domestication, which you'll find on page 184, there's a comment that explains some states today define conversion the way Oregon does, in a way that picks up both conversion and domestication. And so they define domestication very broadly to pick up those kinds of states. So the idea is, if Colorado is the example they give, if Colorado authorizes something called conversion and it picks up both concepts, then that meshes fine with ROLCA. ROLCA will work with that and assume that what they really mean is conversion plus domestication. So it's intended to harmonize with state laws that are under the old regime, which is frankly what Oregon is today. So starting in on section 1051, you're going to find a lot of common themes from what we've been hearing about this today and last month. 1051A, by complying with this part, a domestic LLC may become a foreign LLC if the domestication is authorized by the law of the foreign jurisdiction. No surprise there. And B is the reverse. The foreign LLC can become a domestic LLC by complying with this part. So I don't think there's anything controversial in A or B. C is this protected agreement concept. And returning to Mosen's point about conversions already existing and not being much of a surprise, as we were covering the last sections, I started scribbling this out. Maybe we should get rid of it, right? Consistent with that comment. And as I was refilling my tea over break, it occurred to me, we don't have something today called domestication. We have something called conversion that includes it. And so I wonder, do we want to say something about a protected agreement that exists today that talks about conversion, which really that does pick up domestication under today's law? Should we have that? Should we have this provision basically modified to say, if you have a contract that calls conversion out, that does mean domestication as well?
As a transition rule? Because I
no,
think
just following the contours of this, it would just replace the wording to say, if you've got a contract that talks about conversion, you get the benefit for domestication as well until that provision is amended. So yeah, sorry, Valerie, to the extent the provision gets amended, then this no longer applies.
I think that makes sense in this context.
Yeah, I agree.
I think it makes sense as well. Particularly, we may have some states that never have domestication, but most states have conversion.
Yeah, agree.
So is there suggested language that you would like?
Yeah, I can do that offline if you'd like.
Okay, that would be great.
All right, that's it for 1051.
Look at that.
We're
amazing.
cooking, guys. We're gonna go
cooking.
quick. 1052. This is your plan of domestication. So the domestic LLC may become a foreign LLC in a domestication by approving a plan of domestication. So this is very similar to the prior sections. What you need to include are 1, the name of your domesticating LLC, 2, the name and jurisdiction of formation of the domesticated LLC, 3, the manner of converting the interests, same wording here as well, 4, your proposed certificate of organization of the domesticated LLC. So again, it's a little bit new. If we're converting to Delaware, we need to file in Oregon our Delaware charter docs, but I think that's fine. I think that's a good change. 5, the full text of the provisions of the operating agreement of the domesticated LLC that are proposed to be in a record. Again, same as what we just talked about. 6, the other terms and conditions of the domestication. And 7, any other provision required by the law of the state or the operating agreement of the domesticating LLC. So almost entirely the same as what we just covered on conversion. And then B, in addition to the requirements of A, plan of domestication may have other stuff if it's not unlawful. So I don't think there's really much to talk about there unless anybody has questions or concerns. I would note that the content of the plan is one of those non-waivable, non-changeable concepts in the operating agreement.
Mm-hmm.
Okay, so 1053, how do we approve this thing? Similar to what we talked about in the last one, the concept here is that the organic law of the state where the entity is organized before the transaction is what governs the approval process. So for a domestic LLC, you look at Oregon law to determine how you approve it. And it's again the same structure under A here. Plan of domestication of a domesticating LLC is not effective unless it has been approved by 1, all the members entitled to vote, which you can change in your operating agreement, but the default, as we have discussed in other sections, and I put up a very valiant fight, I will say, for majority rule, but
Very valiant.
I'm licking my wounds. I acknowledge I lost, so this will stay unanimous. And then in 2, we have the same concept we had before, where if a member is going to have personal liability, they have some protections. And this is all totally parallel with what we talked about before. So I don't think there's any need to change. I would note, I was scratching my head for about an hour trying to figure out why in the heck would a member ever have personal liability, because there's no entity change here. We're going from LLC to LLC. And it's because if you look at that definition of interest holder liability closely, it includes more than just kind of the concept of a general partner. You could be liable. I don't know why you'd do this, but you could be liable under your operating agreement. Your operating agreement could say the members are liable for everything the LLC owes. Probably malpractice to draft that, but good. The one example that seemed kind of concrete is the member's obligation to make capital contributions to an LLC is included in the definition of interest holder liability. So that obligation to make capital contributions could be created or go away as part of this transaction. And this helps you helps you protect those people to make sure they're not getting surprised with new obligations they didn't have before. So it took me a while to figure out why this is even in here, but now that I did, I think this makes sense and I think it's fine as it's written.
Okay.
So under B, domestication of a foreign domesticating LLC is not effective unless it is approved in accordance with the law of the foreign LLC's jurisdiction of formation. So again, for the before entity, you look at its organic law from its own state to figure out who approves it. And that personal liability piece, I will flag for you. That's another one that is mandatory. That's not changeable in the operating agreement, which seems kind of appropriate to me. So I'll pause briefly and then jump into 1054.
Nope, I think we're good.
Okay, so amendment and abandonment, very similar again. So in A plan can be amended in the same manner as it was approved if the plan is silent, or 2, by its managers or members in the manner provided in the plan, but a member that was entitled to vote on or consent to approval of the domestication is entitled to vote on the consent to any amendment that will change. And this is the same laundry list that we saw before. So if we're changing the economics, if we're changing the organic documents of the entity, other than stuff that you wouldn't have gotten the right to approve anyway, that stuff all kind of protects members from getting surprised. You voted for the plan and you said it could be changed by majority, and now all of a sudden we're surprising you with personal liability, or now you're getting 50 cents on the dollar, whatever. You get a vote a second round. So I think that's all appropriate.
Okay.
And then B, after the plan has been approved by a domesticating LLC, and before a statement of domestication becomes effective, the plan may be abandoned as provided in the plan. Unless prohibited by the plan, domesticating LLC may abandon the plan in the same manner as the plan was approved. So I think based on our earlier conversation, this rides through and is included just as is. And C, if a plan of domestication is abandoned after the statement of domestication has been delivered to the secretary for filing and before it becomes effective, statement of abandonment signed by the domesticating LLC must be delivered for filing before the statement becomes effective. And then the statement of abandonment takes effective on filing, and domestication is abandoned and does not become effective. So probably all exactly as you would have expected it. And the handful of things that need to be included in that statement of abandonment: the name of the entity, the date on which your prior statement was filed, and a statement that you have abandoned it. So really just kind of all flows directly from everything else we've decided already.
Okay.
1055. Statement of domestication must be signed by the domesticating limited liability company and delivered to the Secretary of State for filing. Statement of this is B. Statement of domestication must include, oh, sorry. So again, they've split it up, right? We've got the plan of domestication, and then we've got the statement. The statement is the public document.
Right.
So the public document in B must contain, number 1, the name and jurisdiction of formation of the domesticating LLC. 2, name and jurisdiction of formation of the domesticated LLC. 3, basically that you've been approved under your state's organic law. So if you're domestic, under Oregon law. If it's the other, then it's under the foreign law. 4, the certificate of organization of the domesticated LLC as an attachment. So again, your new charter document for your after domestication entity. So not a whole lot needs to be included. And then C says, in addition to the requirements of B, statement of domestication may contain any other provision not prohibited by law. D, certificate of organization of a domesticated LLC must satisfy the requirements of this act. So it has to qualify as articles for an LLC. And again, its certificate does not need to be signed because it's attached to something that's signed. E, a plan of domestication that is signed by a domesticating domestic LLC and meets all the requirements of B may be delivered to the secretary for filing instead of a statement. And on that filing has the same effect, and then references are harmonized. I don't know why anyone is ever going to do this because you're going to have to file that full operating agreement. So I probably wouldn't do it, but maybe there's a scenario where that's useful. F, this is now when is it effective? F says if the domesticated entity is a domestic LLC, the domestication is effective when the statement of domestication is effective. So kind of inbound, Oregon law governs. When you file it, it's effective. And that makes sense because you're repping in the document that you've complied with the other state's law already.
Right.
And then the second sentence, if a domesticated entity is a foreign LLC, the domestication becomes effective on the later of the date and time provided in the organic law of the domesticated entity and when the statement under this section is effective. So again, just trying to avoid any gap where it disappears in one state and reappears in the other state. You want that to be simultaneous. I don't have any suggested changes to that one either. Oh, I'm sorry. We do have one change. We talked in the other sections about making the plan available and having that be something that's stated in the statement. So I think we would do the same thing here. We would say that the plan is available for inspection at the company's office if you're not actually filing it with the secretary.
Yeah, and I'll draft that language to circulate to the crew.
Right, and we're also going to strike the end time in F1, I believe.
Yeah, that's right. I'm not sure I was here when that was discussed, and I won't make you I won't ask you to rehash that. But I assume whatever the reason whatever it was good, and surely it needs to be consistent regardless.
Yeah.
1056, effect of domestication. So A, when the domestication is effective, 1, the domesticated entity is governed by the new foreign states law. And 2, the domesticated entity is the same entity without interruption as the domesticating entity, same as everywhere else. Number 2, all property of the domesticating entity continues to be vested in the domesticated entity without transfer, reversion, or impairment, same language. 3, all debts, obligations, and other liabilities of the domesticating entity continue as the same thing for the domesticated entity. 4, except as otherwise provided by law or the plan, all the rights, privileges, immunities, powers, and purposes of the domesticating entity remain in the domesticated entity. 5, the name of the domesticated entity may be substituted for the name of the domesticating entity in any pending litigation. 6, the certificate of organization of your domesticated entity becomes effective, that attachment. 7, the provisions of the operating agreement basically come into effect, the ones that were part of your plan. And 8, the conversion of equity takes place as provided in the plan and subject to contractual appraisal rights if you've got them. So that's really just all pretty straightforward translation from the prior sections we've already talked through. Under B, except as provided in the organic law or operating agreement of the domesticating LLC, the domestication does not give rise to any rights that a member, manager, or third party would otherwise have upon a dissolution, liquidation, or winding up. I think just trying to be clear with people what the heck this domestication thing is. It's not a dissolution. And then C and D are the interest holder liability concepts again. And I won't read them in detail. I don't think it's necessary. It's basically the same concept. You know, if your interest holder liability is going away, or you're not going to have it for the post domestication transaction, that doesn't mean you're released from whatever you had prior. That stuff's all kind of preserved. And then the other direction, if you're now walking into personal liability, you're not liable back to the beginning of time. It's from the time of the domestication. So I think that all flows again from what we've done before, and it's the exact same sub list under D 1 through 4. Under E, when a domestication becomes effective, a foreign LLC that is the domesticated entity may be served under section 119. So again, if you're leaving the state, this is how we serve you. It's kind of the same as everywhere else. And if the domesticating LLC is a registered foreign entity, the registration of the company is canceled when the domestication becomes effective. That's that same house cleaning point. And G, a domestication does not require a domesticating LLC to wind up its affairs and does not constitute or cause the dissolution of the company. They're very afraid people are going to think this is the end of the LLC. It is not. Let us tell you 2 or 3 times. I think that's it.
Yeah, does anybody have any additional questions or concerns about this section that I guess we went through very quickly because we've already sort of hashed through a lot of the issues?
Do we
Can I,
want?
can
Go
I
ahead.
just get a reminder of what we decided? There was an ORS provision that talked about liability and giving a year for people to file. Am I making any sense?
Yeah,
Yeah,
that's 479G.
And did we decide to,
yes, that's
Keep
the
that?
language. That's the language that Michael had talked about adding, and I expect we would add it in, you know, in this section as well.
Okay,
since we've
all
done it
right.
before.
Would
That's-
we also want to do
makes sense.
479H, which is the assumed
H1.
business name?
Yeah,
Okay, so we'll put that in.
I think it's H and I actually.
is it H and I?
H?
Um,
I don't see an I.
63497, 1H and 1I.
Oh,
that
497.
after-
Oh, yeah, I was.
I thought it was
using
479.
Well,
Oh,
it's both.
497. Well, it's
479 's
479G
Wow.
and 4971H.
Ah,
Yeah,
And that's in section whatever 6 after B. So James, I would expect that in, you know, 1056, we would add that same language at the same place. Right?
Yeah, I assume these are the same kinds of parallel ads we're going to do throughout,
Yeah.
right?
Yeah.
okay. Yeah, that's just what I wanted to follow up on to make sure I understood that we're just,
No, no,
you know,
it's a
to
good
the extent
reminder
of the
that,
same, we're just pulling in
Thank you for
that language
flagging that.
again.
I blew through it kind of quickly.
yeah, and 479 is the conversion version and 497 is the merger version, but they're both the same concepts.
I thought I was just having some dyslexia there.
I'm stuck on conversion. It's on the brain.
yeah, no, and it's a good reminder that we insert that there, but I think that is the initial pass through. Would it be beneficial if next time we start with going through the definitions, since we've spent all this time going through the actual substantive provisions? Because I think we sort of glossed on the definitions because Mosin was trying to convince us that we didn't need any of this the first time through.
That's not a fair characterization. And it was not connect. I always thought we need to go carefully through the definition section, but I do want to raise the question of what is the most efficient way to do that. I'm not sure just looking at the definitions in the abstract and talking about them is going to be helpful, but I don't know
I
how
think,
else to do it.
well, so what I would propose is that David and I go through them because this was our section initially and flag the ones that maybe require some additional discussion rather than going through, because it's a pretty long section.
And I think you put pins in a lot of things too, so.
Yeah, and I've got some notes in you know, things that we've talked about specifically. So
When are we going to do the 1100s, or did we decide to do those at the end or what?
we already did those.
Oh, we already did
Teresa
those.
Yeah.
Oh, good.
Teresa walked us through those already.
So we're
Um,
done. Good.
Well, and are there other sections that we skipped? I guess that's my question is, does anybody's notes reflect us skipping other sections? Because to be honest, well, let's see. Did we plan to go back and talk about some of these operating agreement provisions? That's the only thing that I had sort of flagged. Revisit 105 through 107.
I think those are at minimum ones we need to revisit, yes.
Okay, so Michael and Jeff, I hate to put you on the spot again, but you guys had section 1 to begin with. Would you mind taking responsibility for the 105, 106, and 107 if we can get to them after David's and my walkthrough of the definitions next time?
Sure, Michael and I will figure it out.
I mean, I think having gone through this process, we'll be able to have a much more informed discussion about it than we did last time.
So you think we'll get to these the next meeting? We should be prepared for the next meeting?
Yeah, I think so.
Okay.
That's my goal. I mean, we've already sort of walked through them at a high level once, but I think that there's some additional things that we wanted to talk through.
And did we set a date for the next meeting yet?
Yes, that's what I'm just looking at. Hold on. Let's see. September.
Thursday, the 9th.
Oh, okay, that works.
It's good. You're able to get there faster than I can. I don't understand why it's not letting me get there.
Yeah. I have that on my calendar.
Okay.
Thank you.
Let's, I mean, we've been scheduling 2 out, but let's see if we think we need another meeting after next session. Because I think we will have accomplished a lot of the goals. And then one thing that I do want to talk about is how do we want to go through and make sure that all of our edits and suggested changes are captured. I don't think people have had the time to really go through and do the comprehensive review of your sections. So we may skip a month and allow people to do that, you know, and then circle back and either start walking through or, you know, which would be pretty quick because we just want to make sure that everybody's notes get captured. Bye, Victoria. So, you know, whatever, we can talk about that next time as well, but I just want to make sure that, and that will give us some time to try and get Sean Brennan looped back into this because he's been pretty absent for this process. And I think also John will want to start attending again, maybe. So, okay. Anything else for the good of the order?
Was that a sheep I just heard? I was hearing some bah, like sheep noises. No? Okay, all right. Maybe it's outside my window.
Too much time with Rolka.
All right. And then for those, let's see if I can do this. I'm again dropping the, oh, that didn't work. I'm again dropping the doodle poll link in the chat, and I asked Sandy to send it to, but if you could please respond with your availability. I have had a couple people say that because there's not a pediatric vaccine, they're not comfortable coming, which is completely okay. You know, I just canceled the trip to New Orleans because they're having massive Delta outbreaks and my nephews are in my life. So anyhow, so I'm completely comfortable with what everybody wants to do. But if you would like to get together in September, let me know what your availability is and I'll coordinate something with the Tavern on Cruise. Great. Thank you all. Have a wonderful day. And thank you so much to James and Michael and Jeff for doing such a great job getting us through and out of here, you know, ahead of schedule. All right. Have a great week all.
Okay, thanks.